one of the main centers of knowledge in the world, we intend to be always an innovative institution, both for our students and for society at large. Webinars are offered daily by the schools and units belonging to the FGV. This is a means to exchange knowledge in several fields on relevant and up-to-date topics, information, research, and plurality of ideas. High-level discussions, all of this happening for free, online, and daily. Welcome to yet another FGV webinar. Transmission is about to start. Opinions expressed by members of the FGV staff and by guests participating in online events and transmissions represent only the opinion of the authors and not necessarily that of FGV. Good morning, all. I wish you all very welcome to our seminar on challenges in modern regulation. Opinions expressed by members of the FGV staff and by guests participating in online events and transmissions represent exclusively the opinion of the authors and not necessarily that of the FGV. We also reiterate that all participants in this meeting spontaneously agreed to participate and thus authorize the use of their images in this transmission that will remain available afterwards in the official FGV channels. Before I give the floor to the members of the head table, I would like to mention the course that is being a project that counts on the presence of several professors. And this course offers Brazilian magistrates the opportunity to deepen the interaction between law and the economy. And for that, we analyze several books written by the professors participating in the project and also by holding seminars such as the one today. We believe with that we participate in the perfectioning of our magistrates. I will now give the floor to Professor Carlos Ivan, President of the FGV. Good morning, all. I would like to greet, first of all, Justice Luiz Fux, President of the Supreme Court, and I thank him for being with us today. Minister, we are extremely pleased and honored to have you with us. I would like to greet the illustrious Professor Jean Tirole, who joins us from France today. And I thank you, Professor Tirole, for being with us. I also thank Dr. Isaac Sidney, the President of the Federation of Banks. A few years ago, we decided at the Getulio Vargas Foundation, which is known for its tradition in the study of economy and public administration, we decided to develop new areas of study. And it was a project from the 60s. So we created two law schools, one of them in Rio and one of them in Sao Paulo. These law schools, they were created with the following idea. Brazil has excellent law schools. We will try to create another two. And why another two law schools? Not to do the same thing as the other schools were doing, but in order to do new things, to try and understand the world that was changing very quickly. The world was no longer working based on past experience. The world was now trying to foresee what was coming in the future. So one of the schemes that we guessed from the very beginning at the foundation, and I thank Professor Sérgio Guerra, Professor Villen, and Professor Bachelard, along with others who participated in this project, we felt that regulation was a topic for the future. And this was 15 years ago. Nowadays, it is a current topic. The issue of regulation is something extremely subtle and extremely important for the economy. It should not be mistaken with a regulation, which is something traditional. Well, in the past, it was believed in Brazil that much could be sorted out just by regulating things and leaving the solution of problems in the hands of the courts if there should be problems. However, we started to detect that there was a need to try and create a framework permitting economic and social activities to be developed in a smooth way, in a way that should be more favorable to investment, since we realized investment was necessary in several areas, especially in public services, banking services, and so on. Very well, so moving forward, we saw the following. It is impossible to regulate everything. It is impossible to consider that everything is solved and published on a piece of paper. We need common sense, and common sense needs to be well defined. What is common sense for us? Well, there was much literature already on the balance between oligopolies and the rights of consumers. There was plenty of literature since the 30s. There were discussions also on monopoly competition. There was literature on that as well, especially from the 80s on, with work by different authors and so on. But in reality, the main thing is that you needed to create an environment of trust for investment. For Brazil, Brazil is a country that still faces challenges in its budgeting process. The country cannot yet project stability in public finance for the long term, permitting a benchmark that is sufficiently strong in public expenses, not strong enough for investment to be attracted. So it was important for regulations not to create new obstacles. Also, in good faith, maybe a situation might be created where these rules would harm the development of the economy. For instance, the regulatory game is a temporal game, and the players involved will be trying to maximize their results vis-à-vis the other agents. This game develops extensively. It's a true extensive game with a full formation, and the design of the game is altered due to external influence, and you could then have certain notions that in technical terms would mean the following. I don't know what will happen tomorrow, but if I have reasonable variations without very big shocks, I must have a structure allowing for rationality and reasonability in my decisions a long time. In other words, I am not forced to change my mind constantly to react to ad hoc regulatory changes. In other words, I am talking about the creation of an environment where you have perfection in games, you have sequentiality in games, and so on. The problem of creating this fitting and the creation of this stable environment goes through the judiciary power, because it's the only place that can say sometimes that they are not to become involved with a certain subject. So in our law schools, we studied around topics related to socioeconomic development of Brazil, understanding that this development depended on the increase of sophistication of the models we use to perform our day-to-day governance. This said, 15 years later, I would say we made a little progress. We have a long way to go still. And there is one fundamental factor, which is the capacity to innovate in our Supreme Court, represented by its ministers, its justices. Their role has been fundamental along this process, and we on our side have started to defend some visions. One of them is the following: there must be some adaptability a long time in what concerns a regulation. First of all, regulation must be light in order to allow for that. Second, this adaptability of regulation must not become a rule and then change rules every day. No, it can evolve, but it's needed because underlying conditions are changing very quickly. This is why this seminar here today is extremely important to our ideas. We have Justice Fux here, we have Professor Tirole, and all of these ideas are evolving. There is, I believe we can learn a lot from what is done abroad, but we mustn't copy things precisely. We have to try and understand and see what adapts to us. We have to understand the underlying hypothesis and see if they are the same here. If they are the same, we can copy things from abroad. If they are different, we have to understand the difference and try to adapt them. So I thank you all for participating, and I come here today to learn. Thank you very much.
Thank you, Professor Carlos Ivan. And now I turn the floor to the President of the Supreme Court, Justice Luiz Fux. Thank you, Mr. Justice.
Ministro, seu microfone está desligado.
Minister, your microphone is off.
Agora me ouve?
Agora
Can
sim.
you hear me? Yes, we can. I'm so sorry. So, first of all, I would like to thank FGV Law School for this invitation, Challenges of Modern Regulation, and I would like specifically to thank Mr. Carl van Simonsen Leal, president of the Foundation Getulio Vargas, his accedents. We met recently in an event from FEBRABAN, Professor Sérgio Guerra, which is the director of the law school from FGV. I also would like to thank the Foundation Getulio Vargas for this illustrious invitation to be in an event with such great speakers like Professor Jean Tirole, a French economist that received the award of the Nobel Prize in the year 2014, and Professor Oscar Villanos Vieiras. He is also from the Foundation Getulio Vargas in São Paulo. Although I am from UERJ and from the Rio de Janeiro University. I know the meritocracy of the FGV. It is an institution that is well known internationally for the courses that are so innovative, and also the pioneerism in the study of the economic regulation and of regulatory law. And also, I already was part of a program in this university. So I am sure that this event will bring enormous discussions, very interesting, about the challenges and the new perspectives for the regulation in our modern world, because this is known in the Brazilian world. During the 90s, we have seen major challenges in the academic discussions, in the political economics of the reform and of the administrative structure, and the use of regulatory tools available for the Brazilian government. And we started with a paradigm of the regulating state in Brazil, a great new thing. And during this period, the national policy had the structure change a little bit with government initiatives such as the National Program for Destatization that was included in the line 18,081. But the implementation of these initiatives demands institutions that have a compatible legal framework to promote all this structure, or this new structure, this new conception of the regulatory activity. That's why we saw the proliferation of the regulating agencies here in Brazil, together with the support of the sizes that I understand to be of their importance. We work in the field of legality, so the legal dimension and also the other dimensions and the sectorial laws are very important to the regulating agencies. And in 2019, we established the principle of efficiency for the public administration. And also, we cannot deny that jurisprudence are the formal point for the law because of the importance that they receive from our ordaining. And also, I have to highlight that the decisions of the Federal Supreme Court promoting the creation of agencies like Anatel was very important in this dimension for the creation of the regulating agencies. And last but not least, I would mention the doctrine itself. And here I would like to highlight, recently we inaugurated the magazine Supreme for the Supreme Court with scientific articles, with the collaborations of the major players of our academia and our legal world. And FGV has contributed to this discussion with the publication of pioneers articles about this topic on the law of the magazine of administrative law, and with the book Regulation of Brazilian Multidisciplinary Vision, organized by Professor Guerra. And they gave me the honor to participate in the introduction of this literature. The current scenario, the modern scenario, is very different from the 1990s, as it always has to be. We have greater challenges because after the consolidation of the regulating state here in Brazil and the world in general, complexities were added, other functions of the regulatory activities that are performed by the responsible agencies, always trying to use the best tools available for the performance of the regulatory job, just like the regulatory impact, for instance. Today we discussed a lot about the regulatory activity that sometimes comes to the field of expropriation in the legislative field of the constitutional amendment, which is a raw material that I use every day, and the laws from 2021, they were enacted, and even in Article 37, there is a determination that the agencies should promote assessments of public policies, and also with the promotion of the results achieved of the assessments of these results. And numerous new legislations were approved here in Brazil. It's important to mention this for the understanding of Professor Tirole. So here in Brazil, we had a major change on the law of super right, which was the law that was enacting on the civil rights. And we have new regulations today that mention, very interesting, about the consequentialism that today is one of the great foundations of the economic analysis of law, explored exactly by the School of Chicago with economics, but now the economic analysis of law in Harvard with great expectation, like Ms. Chanvel, a professor from the Sorbonne, Professor Milty-Kolitsky, and other professors of Harvard that are dedicated to this subject. And this new law of introduction of the rules for the Brazilian law brought what the economic analysis calls as official pragmatism of consequentialism that must also be applied in the administrative spheres that control, and also to us in the legal and judicial spheres. So we need in the regulatory activity to anticipate the consequences of those rules and regulations and the systemic risk that can come with it. And I also highlight as a new and influence law, the legal framework for the regulating agencies that is from 2019. And finally now, the Declaration of Rights and Economic Freedom is very important in this period of pandemics, especially on the part that it brought a real vision of the moment, as expressing all that we are living and knowing that we have to adopt a solution that answers with reasonability all that is going on. And this is very important because today we know that the legal regulations, they are made according to the situation, and in exceptional moments we have to adopt measures that are exceptional as well within the rule of law, all right? And in the terms of COVID, the Supreme was always performing according to this parameter, admitting the exceptions, but according to the rule of law. I even suggest that you get acquainted with the internationalization of the jurisprudence of the Supreme Court through those studies that were translated into English, internationalizing, exporting our regulations. We were one of the courts that more produced in terms of subjects related to COVID, in terms of the laws that we already have the second volume, and it's found in the digital library of the Supreme Court. In the academic arena, new evidences and factual and empirical have been introduced, and the theoretical diagnoses about this phenomenon have been sophisticated, especially when we analyze the methodological and theoretical approach that brings great foundations to the economic analysis of law. And here I would like to open a practice for this behavioral economy that seems to be a paradoxal name, but the truth is that the economic analysis of law works with the cognitive psychology. So behavioral economy, for instance, explicits that the regulatory activity becomes a rational activity that brings the feeling of justice to the regulated activities, that it's not extrapolating, but that can also be met with all the strategies of the regulations, that is a response and based on risks. I remember of the text that was published by Professor Berkova, Wiles Regulation, where he shows that the regulation is a topic that is multifaceted and demands a better definition. So there are several visions, several definitions that are proposed in this report by, for instance, Professor Steger and other professors that are very well known. Despite of this exponential promotion and political debates, regulation, especially in the taxonomic world, you can see that it has varied a lot according to the field of study of the regulation that has been visualized, like economy, law, science, policy included. And also as well as it has changed sensitivity, according to the vision about how would be the best level of the state intervention in private activities, taking into consideration what the Constitution says about this intervention in terms of economical levels. Whatever it is the definition that we adopt, or the political ideological range that we adopt, it is a consensus that the framework of the regulatory policies that are robust, that they come with the implementation of efficient follow-ups, and it consists in a central element for our study. And we have to always report to the recommendations of the OCDE about the policies of regulations for their state members. As to tell you the truth, to find a good efficiency. And this is a very important word because economic analysis is based on the efficiency of the law. So it is very important so that we can have efficiency on the structure, on the implementation, and on the follow-up of the regulatory policies and their political instruments that all have to be based on an empirical, concrete evidences about elements like risk analysis of the existing risks, about the trade-offs of the institutional framework of the social demands, what measures will provide answers to these social demands, institutional framework, what are the purposes and the segments that are benefited by the measures, and the agents that will pay and support for the regulatory burdens that are implemented. And this brings another issue related to the economic analysis, which are the costs of transactions that already exist and generated by the new measures, the impact and the dynamics of competition, the particularities that are referred to the specific regulated sector, and the political objectives that one wants to make concrete. So based on these assumptions, and with this short time, not only because of the event, but I also have to confess, because of this very intense work, the program of the judiciary, I want to once again to congratulate the graduation program of FGV, because they are involved in this research of regulatory governance that is interdisciplinary and includes other areas. And this is an innovation with a great approach. And also congratulate the institution for the organization of the event that can contribute a lot for the development of the academic debate about the discussions of the contemporary interfaces. On one side, the state regulation, and the other side, the private self-regulation of the economic agents. And last but not least, I would just like to make a note. I like very much the opening of the event when we question if sometimes the judiciary should not intervene, and more, I am aware that the judicialization of the social issues and policies is an expression that is totally misled, because the jurisdiction is not a function can be performed ex officio. It is something that is demanded. Every time that the Supreme Court interferes in a political issue, the reality is that the politicians, they demand the judicialization because in their own arena, they cannot meet the solutions for their intentions. And today, Professor Vilhena here, who is an expert on this topic, knows that the great virtue of the constitutional sources is the passive virtue, is to decide and to receive the problem and to analyze it. So this regulating agents has a very important role, and the more empowered they are, the more state agencies they become, the more efficient these activities will be. So thank you very much to be able to participate in such an important event that brings these different exponentials, and here I render my tribute to Professor Tirole for his presence also. Thank you very much.
Muito obrigado, Ministro Fux.
Thank you, Minister Fux. It's always a brilliant participation to our events. Now I would like to invite to his words the President of the Brazilian Federation of Banks, Mr. Exact Sidney. Welcome, Mr. Sidney.
Thank you very much for giving me this opportunity. I would like to greet the President of the Supreme Court, Justice Fux, who just addressed us, and I would also like to greet Professor Carlos Simonsen Leal, the President of FGV, Professor Bacelar as well. It is a pleasure and an honor for FEBRABAN to participate in this meeting. I was trained in law. I was an attorney for 6 years, and I could follow closely the activities of the main regulations on our banking industry for 18 years. And since 2019, I've been working in the financial sector with another point of view, another perspective. FEBRABAN represents banks. Banks are a strategic sector of the economy, administrating the daily banking work of all the Brazilians. And FEBRABAN has to oversee that. We also try to regulate financial products and services. Our constitution, from its very beginning, provides that the national financial system must be structured in order to promote a balanced development of the country and also to cater to the needs of society. The central bank regulates the sector. All over the world, the financial sector is very strongly regulated, and Brazil could not be different. There is strong regulation, especially because the financial sector is of vital importance to the economy. And this applies to anyone selling things on the streets, all the way to a very sophisticated industry, because finances permeate the whole of the economy. So to discuss financial regulation, banking regulation, and voluntary commitments banks have, all of this is essential to guarantee the balanced economic development as provided for in the Constitution. Also, it helps to prevent conflict in consumption relations, and it also prevents risk for the economy. Minister Fux just mentioned regulations focusing on risk. Our Brazilian banking sector is humongous. There are millions of transactions every day. Last year, we had over 100 billion financial transactions, and most of these transactions were carried out using cell phones. We have lots of accounts that were worked using cell phones. These accounts on cell phones went from 90 million to 200 million, and they were very helpful in the emergency help that we gave the population due to the COVID pandemic. When we stopped paying the emergency aid, we still had an increase of 40% in the number of banking accounts. We have about 40,000 bank agencies all over Brazil in about 3,000 municipalities. It's 203,000 correspondents and 460,000 ATMs. This shows the magnitude of the Brazilian financial system. Of course, we have the concern to minimize errors and avoid conflicts, and regulation and self-regulation are very important in this process. We are aware of the fact that in view of the very large size of our financial system, many controversies are taken to consumer defense agencies. And we try to serve the millions of users of our services. Our initiatives try to eliminate the need for cases being taken to courts, but it's not always possible. So the question we may ask is, what should we expect from a good banking regulation? Maybe I could point out, first of all, at the fact that banking regulation should guarantee resilience to the sector. And surely this will make this regulation impose limits and adequate capital requirements, and above all, risk control mechanisms and also leverage mechanisms and protection to people with lower purchasing power. We wish to minimize the possibility of a banking crisis, and if this should happen, the effect on the other sectors of the economy should be reduced to a minimum. And there seems to be no doubt, therefore, then, that the main objective of regulation is to preserve the health, the safety, and a quick response to the financial system, which is a need all over the country, and especially for the economy. In this process of a health crisis we had, showed the importance of having a solid, well-capitalized banking sector capable of offering credit. About 5.7 trillion reais were made available to irrigate the economy and provide resources to help companies. And this helped to minimize the recession or recessive effects of the health crisis. What I like to underline in banking regulation is that it should be neutral. It should interfere as little as possible in the functioning of various sectors. In other words, a neutral regulation should be symmetrical. It should guarantee the same treatment to all participants in the market, avoiding a regulatory arbitration. This arbitration happens when competitors who have similar capacity in terms of competition and who have the same risk potential, when they receive a different treatment, for instance, due to the origin or any other characteristic. In the domestic sector, asymmetric treatment favoring one agent more than another will make it all migrate to less regulated categories. This is not sustainable, and therefore it seems clear that an asymmetry should remain in the long term. We will weaken the whole banking industry, and this will jeopardize the first pillar, which is the health of the financial system. So regulation guarantees safety, resilience, health, and on the other hand, it should be neutral. Along with this state regulation, the banking sector already for a long time, for 13 years, has adopted self-regulation. And this self-regulation is the result of our constant dialogue with consumers and with the central bank. And we have 16 sectors to carry out our relationship with consumers. And I would like to close by saying that the banking sector has an agenda focusing on transparency, responsible credit, education for debt, financial education, and protection to the more vulnerable, with less conditions to work with the financial sector. We also greatly encourage platforms and services to reduce complaints banks are inserted in a platform called consumer.blog, and out of every 10 complaints, 8 of them are sorted out on a friendly basis and without resorting to the judiciary power. We give priority treatment to our customers, and out of every 100 drafts out of banks, only 1 are taken to the judiciary system. So 99% of our users have their requirements, their needs met. So we're working with this self-regulation along with regulation itself. We have a commitment with good practices, and that strengthens the role we have to guide our clients well. This event today stimulates the cooperation and integration between all the participants from the financial industry, the judiciary power, the academy, and so on, for us to continuously improve the regulatory activity and the adoption of best practices. I thank you all for having given this opportunity to FEBRABAN. Thank you very much, Isaac. Professor Sérgio Guerra, Director of FGV Law School, Rio. You're most welcome, Professor Guerra. Thank you, Professor Porto. I would just like to make a brief greeting on behalf of FGV Rio to all the participants in this meeting. Professor Carlos Ivan, Justice Luiz Fux, Minister Fux has issued several decisions that are very important for regulation. As he said, they are very complex, and there are many difficulties to understand their meaning. And flexibility in the standards, and we have been following all these decisions closely. I would also like to greet Dr. Isaac Sidney, the President of the Federation of Banks, and mention how pleased we are to have Professor Jean Tirole attending our seminar. He will talk about this topic, as we heard in the opening, and its importance increases. It involves law in the economy, and all of this is very relevant for the development of the country. And as our minister said, this leads to the consequentialist analysis of the impact of decisions made by the judiciary power concerning the financial sector and so many other sectors. The electric power sector, for instance, is going through a crisis right now. So all of this requires consequentialist analysis, and in order to determine their efficiency. Well, as Professor Porto said, the law, the economy, and justice, all of this is part of our center. I would like to thank the whole team who prepared this meeting. I wish you all an excellent meeting, and I thank my colleagues, Professor Goret, Professor Viana, and I wish you all an excellent meeting again. Thank you, Professor Guerra. Well, I will undo this head table, this virtual head table, with the participants in the opening, and we shall now listen to our keynote lecture. We have the honor of having Professor Jean Tirole avec nous, and he is part of our lives. Whenever we have difficulties. We go to his text to find inspiration. But I would like to mention a few things that are part of Professor Jean Tirole. He's a French economist, honorary president of the J.J. Lafon Foundation, of the Toulouse School of Economics, a scientific director of the TSE Partnership, and affiliated of the MIT, where he holds a visiting position. He was awarded several international distinctions, including the gold medal for France CNRS in 2007 and the Nobel Prize in 2014. His research covers industrial organization, regulations, finance, macroeconomy and banks, and psychology-based economy. He issued 12 scientific books, and the latest book was launched in 2017, titled Economics for the Common Good, and it is available to the public in several languages, including Portuguese. It is a pleasure to give the floor to Professor Jean Tirole.
Well, good morning, and thank you, Antonio, for those kind words, and thank you also for this invitation. It's a great honor to be speaking today for several reasons. The first reason is, of course, that the reputation of FGV, which is pretty well known, including outside Brazil, by the way. It's very well known. Of course, as an economist, I know the economists better, and there's a superb team of economists, but it's broader than economics. It's very important to bring together all the social sciences, and that's what FGV does as well. Another reason to be honored is, of course, a group of people who are speaking, who have already spoken earlier. It's a highly distinguished group, and also the panel later on. So thank you so much for inviting me. What I'm going to do is to share with you a few thoughts about privacy in the digital age. So I should say right away, it's going to be an economic perspective on privacy. It's going to be consequentialist, and that's something that is going to be very clear from the start. It's going to be an economic perspective. I'm going to take you through a little bit some of the research I'm doing now. I mean, rather immodestly, but I have to apologize for that. But I think privacy is a good topic for this keynote, because that's a topic which actually we don't know that much about, especially for what's going to happen in the next 10 or 20 years. But also a topic which is of interest to economists, to psychologists, to legal scholars, and we are at a law school conference today, to sociologists and many other social scientists. So this is a broad topic. So let me try to share my screen, which I've been doing for almost 2 years now. So I hope I'm not going to get it wrong. Here we are. So hold on a second. Okay, so can you see my screen? Okay, so again, thanks so much for inviting me. What I'm going to do then is to discuss various topics on privacy. So in terms of the future, due to the new technology, of course, there are very high promises, very high living standards, much better health, some prospect for more inclusiveness. But that's not what I want to discuss today. I would like to discuss the renewed concern about the loss of agency, the rise of the surveillance society, which is due to two things. Those concerns are due to two things. The first is a technological evolution. Now we have smartphones, we have AI, facial recognition, social networks. So basically there is an expansion of our public sphere. But there are also various societal development, and most notably, of course, the Chinese social credit system, which will give to each citizen and to each firm, domestic and foreign, grade, which a lot of consequences we could discuss later on. But there are milder forms elsewhere, and of course, it's going to come to other countries as well. We have seen platforms subverting democracies, fostering polarization of views, And we also see changing social norms. So for the moment, it has become more common to dox, to out, or to chase people, and basically restrict their privacy. Meanwhile, we see some regulatory development, in particular in the European Union. So for example, on the right to oblivion, there's been a European Court of Justice decision in 2014. More well known is, of course, the General Data Protection Regulation of 2016. And more recently, we had the Artificial Intelligence Act, which is also very interesting to read. Now, the outline for my talk will be, of course, the common good and the link between data and the common good. So I will start with a few thoughts about the right to know about what is being done with our data. Then I will make the case for transparency. Third, I will make the case against transparency and ask ourselves, what harm can data collection and dissemination do to the individual and to society, to the broader society? And finally, I will discuss the advent of social scores. By the way, the European AI directive, I mean, it's not enacted yet, but it proposes actually to outlaw social scoring. So let me start with the right to know. There are 4 concerns about what is being done by platforms with our data. The first is that the platforms can share data without our consent. That's not the biggest thing in my view. The bigger thing is that we may not actually grant an informed consent. So that's item number 3. Whenever I go on a website, I often don't know what the terms exactly mean. I don't know what are the 150 partners who are going to get the data later on. I don't know their privacy policy. I don't know whether they will respect the right to oblivion, the absence of resharing, and so on. I've concerned also about the insufficient investment in security, which of course is a very standard topic in law and economics about the standard of care and the amount of liability. And finally, number 4, there is what I will call the unavoidable sharing. So even if you don't go on the internet, it's hard to escape the internet because other people will go for you. So even if we never grant consent, even if we never supply data ourselves, then our social graph, our friends, our colleagues, our family will share information about our health, about our politics, about our tastes through their emails, through social network discussions, through posting pictures and the like. So actually there is a lot of information which will be known about us, even if we are never on the internet. And also there is indirect disclosure. It's a bit less serious, but it's there. The fact that, for example, academics will have similar tastes means that if other academics go on the internet, then the platforms will know something about us. So we have had GDPR, and GDPR, my own view on GDPR, we can discuss that later on, is that it's well-intentioned, it's welcome, but it's really a first attempt. It's still, when I see my own behavior, I haven't changed it very much. I keep on clicking all the time. It's very hard to follow the consent form, and they actually made very difficult to follow intentionally. And there is not a huge amount of progress. There are also competition policy concerns I don't have the time to talk about, but I think we do need regulation, actually even more regulation than GDPR, both to protect the industry and to protect consumers. Why? Because if you think about GDPR, it has cost a lot of money to the industry, but at the same time, as a consumer, I don't feel protected very much. So again, I welcome GDPR, but we have to do much better. And we need that. Let me give you some analogy. In banking, for example, you could say, I, as a depositor, I could monitor my bank and run every time I think my bank might go bankrupt. So I could spend all day and all night, assuming I have the data and the knowledge, monitoring the balance sheet and off-balance sheet activities of the bank, which of course will be terribly inefficient on top of being undoable. And of course, there are regulators doing that. Same thing if after this session you go for lunch in a restaurant, you're not going to monitor the entire supply chain for the restaurant. Fortunately, there are supervisors, public supervisors, who are going to do it for you because it will be just too hard to do. Last item is transparency or privacy and individual choice. And to some extent it is, but to some extent it's not. Let me start with a privacy paradox, which is that there is a big disconnect between the user's stated preferences and their actions. So I do care a lot about my privacy, but at the same time, as I mentioned, I click very impulsively whenever I want to see a soccer game outcome or whatever. So why, I mean, if you want to talk about regulation, you have to talk about market failures. So why does the market for privacy fail? The first is data externality. So I already mentioned that other people are giving information about you. Then there is bounded rationality, which is that just like any contract, it's always very difficult to read what the contract means, especially for small consumers. And there are very high transaction costs of granting informed consent. I discussed that, but on top of that, it's compounded by impulsiveness. So we may work against our best interest. And finally, there is the issue called unraveling. Economists call that unraveling, but just to understand this notion, just think about you are looking for a job and the employer tells you, give me access to your Facebook private page. Now, legally, you have the right to say no. But the problem with that is that if you say no, then the employer might think there is something suspicious and you're not going to get the job. So, you know, the nothing to hide issue is a big issue because even if you have the right to say no, I'm not going to give you the information, then you may still have to give it anyway. Where to place a cursor between transparency and privacy? Richard Posner, a long time ago, had an interesting article in which he said at some point non-disclosure becomes fraud. It's really the nothing to hide argument. And that raises a question, may transparency ever be suboptimal? At the same time, we also see science fiction. I mean, you may have seen or read the books, The Circle. You may have seen some Black Mirror episodes on Netflix about that. But probably also aware of what happened in Eastern Germany with the Gläserne Mensch, the glass man person, where the requirement was to be fully transparent. And of course, this is really associated with some kind of totalitarian regime. So let me start with the case for transparency. And the case for transparency has been made many times by economists. It has to do with incentives. Transparency creates some accountability. So, you know, career concerns are based on the fact that employers know your past performance. For suppliers, we see that on platforms, you know, the suppliers get ratings. You also have financial, ESG, and whatever rating agency. You have reviews and ranking of school and restaurants, and all that is, of course, very useful. It's also useful to know about politicians or to know about countries. So transparency can create accountability. And according to the proponent of social scoring, that can help discipline citizens as well. Now, there's something true in there, of course, which is there's a huge lab and field experimental literature showing that people behave more prosocially when they are observed by others. That has taken place, or the experiments have taken place for charitable contribution, public good provision, voting behavior, healthcare behavior, blood donation, and many other things. The second case for transparency is allocative efficiency. Basically, the idea is that you facilitate efficient trade, maybe by restoring the symmetry of information that is going to lead to no breakdown of trade. Conversely, you may avoid wrong matches. So, for example, transparency may help women or children to stay away from sexual predators. It may help citizens not to elect a corrupt politician. So this is pretty well known. And what I would like to discuss in more detail is a case against transparency. And the first issue with transparency is that it's going to lead to posturing. It's going to change your behavior. And here, I appeal to the philosopher's view that privacy fosters emancipation and authenticity. So, for example, Bernard Williams was saying to act morally is to act autonomously, not as a result of social pressure. Jean-Paul Sartre has talked a lot about this as well. So there's this view that if you have privacy, you'll behave in an authentic, efficient way, in a sense. And transparency, in that view, may create too much accountability. And that's what I'm going to develop. So I'm going to distinguish between consensual issues. Consensual issues are basically issues for which people agree on what is morally right or wrong. So people think that, almost everyone thinks that polluting is not very nice, committing a crime is not very nice, beating one's children is not very nice, and so on. I mean, everybody agrees on those things. And even for post-consensual issues, you sometimes may have too much transparency. So that occurs for very small externality, like, excessive politeness might be an example of that. People wishing happy birthday to Facebook friends. They hardly know, actually, they don't even know who they are sometimes. Some kinds of norms of etiquettes which are excessive and so on. So basically, excessive attention to self-presentation. I don't think that's a huge issue. I mean, it exists, but it's there. Something I've been working on with some colleagues is a coexistence of private and public sphere. So once an individual acts both in the private sphere and the public sphere is the activities which are observed by many other people, not only the people you interact with, like your family or your close colleagues. Then there is kind of transfer where a lot of attention is put on the behavior in the public sphere and too little attention is put on behavior in the private sphere. There's a theory, and the preliminary experiments actually go in the same direction of the theory. So some kind of crowding out of good behavior in the private sphere by the public sphere. But I think, in my view, the biggest problem is divisive issues. So divisive issues is basically things like sexual orientation, politics, religion, and many other things like abortion, social roles, vegans versus meat eaters, and so on and so forth. So basically, issues for which people don't agree about what's right or what's wrong. And actually now vaccines, unfortunately, is also divisive issues. Even so, in my view, it should not be a divisive issue, but it is. So the problem there is that transparency may fuel ostracism, discrimination, hatred, violence. It could be by employers, by coworkers, by blackmailers, by governments, and so on and so forth. So that's really a big issue there. The problem with transparency there, the fact that your behavior is observed by others, means that it can change your behavior. So it could have what's called a chilling effect. So people don't dare to speak their mind because they are afraid of antagonistic reactions. They may not check into a drug rehab center or share their information with a physician if there is no assurance of privacy. Then you may have obedience to majoritarian views on religion, sexuality, soft drugs, and so on and so forth. So people may not be authentic at all. They may rechange their behavior a lot compared to what they would like to do. They may keep the same behavior, but also hide in what's called safe spaces. But that has cost, of course, for example, a reduced use of public spaces. So a sexual minority, for example, may not enjoy the public space together. And we have seen, things fortunately have changed, but in many countries, gay people, for example, had trouble enjoying together the public space. Or if you think about drug users or aborting women, may resort to costly and untrustworthy providers. Also, they might also join a safe space in a different way by selecting their social graph, so their friends, which is going to reduce a lot the diversity in their social graph. So this is something I'm doing some work on. Intuitively, when you have divisive issues, again, issues for which no one agrees on what's right and wrong, then there's a demand for what I would call partial transparency. So the individual would like to be submitted to partial transparency. So I would like my behavior to be known to my in-group of like-minded people choosing the same behavior. So the idea is that if they choose the same behavior, they're like-minded. So I want those people to know what I'm doing, but I don't want the out-group to know, because otherwise that will make me shy to act. Now, that demand for partial transparency is going to translate immediately to the notion of retreating into a safe space, which can be physical. So it can be my home, it can be a pride club, it can be a church, a Masonic lodge. If I like corridors, it might be full. It could be virtual, like a Facebook group of like-minded people, because it's going to generate less of hostility from the out-group. But it's not going to generate authenticity like pure privacy will do, because the neutral agents, those who don't take side, are going to be viewed suspiciously by both sides, the left and the right, for example. And there will be private costs. So, for example, I already mentioned the reduced use of private spaces and the foregoing of desirable relationship. Those are costs. Let me just mention collateral social costs of safe spaces. There is a cost to safe spaces, because once you are part of a group of like-minded people, then you are going to change your behavior, and it's not going to be for the best, for the better. Because when we belong to a group of like-minded people, then we all want to show that we are more Catholic than the Pope. That may be on our own doing, it may be voluntary, because we want to signal to our in-groups that we are strong believers. Or it can be enforced by a threat of outing or exclusion from the group. And that's how we get one-sided narratives. So that's very bad for the democratic debate, hate speech, conspiracy theories. And that's what we have seen, of course, in Facebook groups. So what I'm saying is, it's just a collateral damage of safe spaces. But once you get people to mix together in a space of like-minded people, you also have a lot of bad consequences for society. The cost of transparency may be discrimination. That's the second cost I want to emphasize. There's a large literature in economics and other fields about what's called the extraction of the behavioral surplus. The platforms today know everything about you and me. They know her location, her taste, her consumption, her search pattern, her device, whether we have an Apple, an Android, a social graph. They know who our friends are. And therefore, they can pretty much price discriminate or discriminate in other dimensions to extract a surplus. They may also unload their lemons on consumers whose search patterns shows they don't have a clue. I mean, they are good targets for unloading lemons. Also, there will be a breakdown of insurance. This is something which has been well known since Schleifer about 50 years ago. The fact that if the platforms or the firms more generally can discriminate according to the health of the person, then there will be no universal coverage. And actually, the law in each country has reacted to that by either having public health insurance or, like in Germany or in Switzerland and the Netherlands, have private health insurance, but the prohibition of discriminating according to the health of the person. But more generally, there is an amplification of mistakes. There are consequences for personal life. You can very quickly become a social pariah. You can, if you have made a mistake, if you have made a mistake, you have kind of a reduced access to the labor market. If you are poor, you can be stigmatized. And lately, you have had this discussion about algorithmic fairness. And that brings me to some work I'm doing with my colleague and co-author, Renato Gomes, who is actually from Rio, is a Brazilian, and we are very fortunate to have him in Toulouse. We are doing some preliminary work, but many people are concerned by that, the violation of the right to be forgotten. So I'm not going to teach you that, of course, but a very fundamental principle in law and also in many other areas like religions and constitutions is that if you make a mistake, you pay for your misdeed. And then you are given a chance to start with a clean slate. And that leaves open avenues for redemption. You let people move on. You can say it's fair or you can say it's efficient because, of course, you recreate the right incentives if you give a second chance to people. And that shows up in many, many areas. And the most common case in most countries, of course, is that young people can make mistakes. They may be punished for that, but of course, at some point you want to delete the juvenile record of the person so as to give a chance in life to that person. The problem with the digital world is that the digital record may last forever. And that's a very serious issue. Lastly, I would like to talk about data integration and social scores. So that's also something I've been working on. And actually, there's a paper in the American Economic Review published in June on that. So that research starts from the widespread concerns around the world about the China's social credit system. So the Chinese social credit system is going to use big data and artificial intelligence to basically give a public score. It will be fully transparent to each citizen and to each firm. Now, this score is going to embody a variety of criteria. They are not cast in stone. There have been many pilot experiments, but it's it was due to be rolled out in 2020, but of course with COVID, I believe it's delayed. Some criteria are fine, actually. Maybe credit history. Have you repaid your loans? Have you paid your taxes? Have you adopted a behavior which is environmentally friendly? Do you have traffic violations, for example? Now, there's another issue is, what kind of weights you put on them. So, for example, I think if you put the same weight, for example, on jaywalking, you're basically crossing the street in a random place, and on corruption, then something is wrong, right? And so there's the issue of weight you have on each criterion. Some are manipulable. So spreading of fake news will be part of the social score. Now, on face of it, you say it's quite reasonable. You don't want people to spread fake news. But of course, if fake news means that you disagree with the government, then there's an issue, right? So it's a little bit complicated. And then there are clearly unappealing criteria like social graph. So who are your friends? The personal traits, the political or religious opinions. Those certainly should not be there. And in my view, fake news, even so, of course, we're all against fake news, is very dangerous unless you have an independent authority, and completely independent authority from politics, who can check what is a fake news and what's not. And using social science and truth and real science, also experts. Now, what is it for? Well, it's going to be used in two ways. The first way is public stigmatization. Basically, that people will know that you have a score of only 457, and then if you have a score of 457, you are not a very reliable person, and they may not want to trust you, at least not take the risk of trusting you. But it's going to be broader than that, because it's also going to imply some restriction of access to employment, access to transportation. In the pilot experiments, for example, you may not have been able to actually take the train or the plane first class. Now, it's not necessarily wrong. I mean, if you think about someone, for example, who has not paid his taxes or reimbursed his loans, then you wonder why this person is flying first class, for example. But that may be issue. I mean, if you are an opponent, for example, and you are not allowed to have visa abroad, that's a big issue. If you are not allowed to have access to employment, or if your children cannot go to the good schools, which is something which is being discussed, then there is of course a big issue. So if you want to think about this, think about our activities being split between our private sphere and our public sphere. So we all engage in kind of stable relationships with our family, with our friends, our close friends, maybe some close employees, and maybe in our village too. But we also are engaged in more transient relationship on platforms, independent contractors, large city or large firm interactions. Now, we care about our social image, and that's why a social score is going to be so effective, right? Any information disclosure is going to affect us and is going to change our behavior. Now, an agent's behavior, past behavior, may become known to others in two ways. Either through direct experience or interacting with the agent. So, we interact with each other and you know whether I'm a reliable person or not, or you are being told, or maybe there's a social score, which is going to tell you what my behavior has been. So, just think about, you take a Uber taxi and the driver has a very low score, then you might be reluctant to take this taxi driver to accept the ride. And conversely, by the way, the driver may not want me if I'm not reliable. Now, you can think about basically a social score just to simplify, it might be 0, 1. So either you're blacklisted or you're not blacklisted. That's a very straightforward example of a social score. Now, the release of the social score is going to boost the image concern and therefore change the behavior. The agent's reputation will be extended to future new partners, and that's exactly what is happening on platforms. But even the stable partners, they will learn something about us because they get a clear assessment of the social attitude, especially if there is indirect, imperfect observation of all interaction in the pride sphere. Now, the point of the paper I've written is that the state, but also platforms and also religious organizations, I give examples in the paper, they can exploit the agent's interest in each other's social score to promote compliance and political compliance in the case of politics in 2 ways. The first is that you bundle pro-social behavior, which is something that other people are, of course, interested in. They want to know whether you're a reliable person or not, with political compliance. So basically, if you dissent, you might be blacklisted, even if you have good pro-social behavior. And what's really important is actually mix 2 kinds of information through this bundling process. So basically mix information that people care about. So they care about whether you're pro-social or not, but you mix that with political compliance so as to force people to accommodate the state to not dissent. That's the first mechanism. The second mechanism is to use what's called guilt by association to further eat dissenters. So guilt by association, I'll come back to that, but let me just say right away, this kind of theory or this kind of approach is not Orwell. You don't need any brutality here. You can use soft control. And soft control is it's a low cost. So, in law and economics, we're always interested in low cost approaches. And I'm sure governments, unfortunately, they're also, in this case, going to be interested in low cost approaches and using those social scores for social control. So I just enunciate the main insights, theoretical insight of that paper. The state bundles the 2 if and only if it is sufficiently autocratic. So if it cares a lot about staying in power and controlling dissenters compared to social welfare. So you put weight on social welfare and you put weight on basically controlling dissenters, and being autocratic, that means that you put a lot of weight on controlling dissenters. The ability to affect behavior through bundling, remember you bundle pro-social aspect with compliance aspect, is much higher in society of strangers, of transient relationships than in tight-knit society of stable relationship. Simply because if you have stable relationship, other people know who you are, and they can figure out that you are being discriminated against, blacklisted, because you are a dissenter. Now, it's important actually that citizens are very well aware of the way the social score is being built, but opaqueness about the inputs, in particular opaqueness about the pro-sociality dimension. And also the state must suppress competition from independent, privately provided social ratings. And I don't know if it's part of the crackdown on the private sector in China, but and I have no clue whether it's correct, but at least the theory predicts that you don't want competition from private ratings, because the private ratings, they will focus more on the pro-social aspect and less on compliance with the state. I was talking about guilt by association and listing the citizen's social graph. So basically, the idea there is to color a person's perception by the company she keeps. So basically, I can comply with the state, I can be a good citizen and so on, but if one of my friends is on a blacklist, I'm also going to be on the blacklist. Now, why could the state use that strategy? Well, simply because it's going to make it even more costly for dissenter to dissent, because they will be ostracized. Everybody will be afraid of being seen in contact or being a friend or whatever of someone who's on a blacklist. So basically, the idea is really to ostracize dissenters as much as possible. And let me just make a remark here. I mentioned the Gläserne Mensch of Eastern Germany kind, 40 years ago, 50 years ago. But now things are different. Now it has become extremely cheap. The marginal cost of knowing your social graph is close to zero. Why? Because AI is going to figure out who you are calling, who are your friends in emails and social networks. There are millions of cameras on the street will record, and facial recognition has gotten very good. So basically, anytime you go with a friend, take a coffee, then the state will know about it. So they will know exactly what your social graph is. And therefore, an autocratic state will be able to use guilt by association to actually crack down on dissenters. Now, this is a very inefficient policy because it's going to destroy the social fabric. As I said, no one will want to be seen or communicate with a low rating person. And there are, of course, already science fiction movies doing, discussing that, but this is very serious. It's there, it's here now. Okay, so it's going to generate cost, but again, it's going to appeal to autocratic regime because it strengthens the state's hold on society. Okay, so I mentioned the Stasi, religious orders have done that. By the way, when they excommunicated people, think of that as being a low score, they also ask their members not to have any contact with the excommunicated people. So it's again guilt by association. But as I mentioned now, what used to be extremely expensive, in Eastern Germany now has become very cheap, and every government now can use that very easily, which is very scary. Okay, let me conclude. And it's clear that our digital future is holding extremely high promises. So the living standards are going to be much higher. If we solve the climate change issue, of course, and we prepare ourselves for the next pandemics, but health will be much better. We could have a more inclusive society. We could discuss why. But for that to happen, we need to solve the societal challenges. And first and foremost, privacy. And to do that, we need economic analysis and confront the ethical dilemmas, which are going to help us build not any random regulation, but smart regulation of privacy. And I very much look forward to discussing those issues with you. And again, I would like to thank you for inviting me. Thank you for your attention.
Muito obrigado, Professor Tirole.
Thank you very much, Professor Tirole. Before we open for questions, a brief comment. At the same time that you bring or you shed light about the points that we hadn't even thought before, you bring some agony to know all the paths that we still have to tread in this universe of digital ways. Now apart, we will be the moderator. And before the first person, I would like to ask or thank you, Professor Araújo. He was not able to be with us today, unfortunately, but immediately I turn the floor to Professor Goretti Paulo. She is Director of the Network Research and Applied Knowledge from the FGV. You're welcome, Professor Goretti. Thank you, Porto. I would like to thank you, Sérgio Guerra, for the invitation to be able to join this very important event concerning all the issues that are being discussed in this country. I would like to welcome all the participants in this event and also all those who are watching us. Professor Tirole, congratulations for your consistent presentation and the challenges that personal data brings and the eventual sharing of these data that could bring. It has been made very clear in your presentation that we are facing many challenges that have to be dealt with. We have potential economic benefits, of course, but we have threats, and the extension to which it becomes a benefit or it turns into a threat, or who will be benefit or who will be threatened, change very much according to what kind of information is shared, who this information is shared with, and how this piece of information will be used by the person who receives it. In the beginning of your presentation, you mentioned that GDPR is a good beginning as a regulation, but it could be improved, that new regulations could appear. So I would like to ask you if you already have any additional thoughts or concepts that should be included or should be thought to improve the existing regulation or eventually in the creation of new regulations. This is especially important for Brazil because the regulation of personal data in Brazil, it is strongly inspired in the European regulation. So we can believe that once this European regulation improves and evolves, we also here in Brazil will receive these benefits of these consequences. And this is my question. Thank you very much. Thank you, Professor Goretti. Professor Tirole, you have the floor.
Well, thank you so much for this excellent question. I don't have perfect knowledge of what should be done, but this is something that definitely I'm working on with some colleagues in Toulouse. One of the things I have in mind is to make GDPR. And first, you need a simpler menu of things because, I see myself a very bounded rationality, and I need simple stuff. And that's my own view. And we don't. It's usual issue that we have discussed already today, which is when you enact a regulation, you don't want to kill innovation and you don't want to make it difficult for business to operate. At the same time, you do need a regulation to protect consumers and citizens. So it's actually quite difficult. So, my own taste will be make the regulation simpler so that, people like me will understand them. But another thing that could be useful actually is to make the regulation viral. So let me explain, which is that I can check the policy of some platform, be able to check that. But then if this platform sells the data to 150 other websites, I'm not going to check the policy of the 150 website. There is no way, no way I'm going to do that. So, I would expect that the terms and conditions I've signed for are respected for whenever the data are resold to anybody else, so that I don't have, it's a bounded rational argument. I don't have time to check all those things. So those will be two possible actions. But again, this is something we collectively have to work on and think how we could improve those regulations. It's a difficult topic, and we social scientists are a little bit behind, and things are moving so fast, and we are a little bit behind on how to deal with those issues, and that's part of a place like FGV and my own institution and other institutions actually to actually anticipate a little bit more the evolutions that are going to happen in those areas so as to be able to build smart regulations.
Thank you very much, Professor.
Muito obrigado, Professor Tirole.
Thank you, Professor Tirole. I would like to call now Professor Oscar Vilhena, Director of the Law School in São Paulo of FGV.
Bom dia.
Good morning to everybody. I hope you can hear me well. First of all, I would like to thank this great invitation to join this conference. I would like to thank President Carlos Eduardo, to congratulate Professor Porto and others. It is a privilege to be here with Professor Tirole, of whom I am a great admirer, although I understand that part that the writing orthographically, either in French or in English, is not a part of mathematics. I don't stop very much on your equations, but anyhow, your text that we are discussing here today is of great importance and relevance for those who work with political philosophy or constitutional law. The discussion about privacy, its limits, about how this privacy is impacted by a digital environment, not only that is very dense and cohesive, but it permeates all the spheres in our life. It's ubiquitous. It's found everywhere. We cannot run away from it. And it is penetrating, which is a new characteristic of a means, because actually it interferes in the sphere of privacy in all the fields in our lives and choices. So it is based on this that comes my concern with this. It is one of the rights that organizes the notion of constitutionality in modern age, but that is together with other rights as this freedom of expression, the freedom of looking for knowledge. So this friction is not new, it's old, between privacy and the right to knowledge, privacy and the freedom of expression. What is new is the strength with which the mechanisms of penetration into privacy happen. So what I would basically like to ask is, first of all, what is your proposal in terms of creating certain principles of policies and law that start with a distinction between public sphere and private sphere, and like this achieve a sensible regulation that allows this penetration to happen in some spheres, not in others. And my question is there today a way of making a clear distinction about what is public sphere and what is private sphere, so that sensible decisions in the regulatory arena can be done? This is my first question. My second question, if we have time, otherwise if we don't have time, discard it, is the point that you raised in several moments about the importance of a law to oblivion, or the right to oblivion, as a tool to struggle against this invasion of the privacy spheres, offering a second chance to people. As you well know, the European Union itself was created and based on the principle of never forgetting, considering the atrocities that happened with the Nazism, and even here in Latin America, we have never forget by the Argentinians, which is a fundamental topic to democracy. Democracy cannot start with the assumption of oblivion. And in 1984, the Ministry of Truth always brought the caveat of the risks of the possibility that we adapt our past to get adjusted to the future. So I ask if this trust on the right to the oblivion as established by the European Justice Court and denied by the Supreme Court here in Brazil a few months ago, is it a tool that is effectively reliable, trustworthy, so that we can face this dilemma? Thank you very much. It was a pleasure listening to you. Thank you, Professor Oscar Vilhena. Before I open the floor to Professor Tirole, I would like to know if Professor Carlos Ivan would like to speak now or after Professor Tirole's answer. After his answer, please, otherwise it can create some confusion. So, Professor Tirole, you have the floor.
Well, thank you, Professor, for your great question. I agree with you that topic is not completely new. What has changed is really the strength, as you say, of those various ways of getting information about us and the fluctuating boundaries of public versus private sphere. Now, I don't, the way as an economist I will define public and private sphere is really who has access to your information, but it's completely endogenous, and I guess that's where you are hinting at. It's completely endogenous. So think, for example, about our interaction on Facebook in a home. It's in the home, but nonetheless, it's in the public sphere. But that has always existed. So, we have privacy, and before facial recognition, we had privacy in a big city, for example. So we may be in a public space, but at the same time have full privacy because nobody knows us. So those are things. So in the end, what's public and what's private is basically who is watching you in a sense, and who is watching you, as I discussed earlier, is completely endogenous. So it depends on whether the state or the platforms have the right to watch you, have the right to keep the data, have the right to share the data, and it depends on us as well, because we can also retreat into a safe space. So that's kind of very difficult actually to discuss. So we need to think a lot more about that, about this distinction. I don't have a formal distinction to offer you, to be honest. And as I say, as an economist, I would just think about, in the end, what are the consequences of making one's life more transparent or more private? And what are my opportunities to do so? So it's really a welfare analysis, which is very classical, but I think the frontier between public and private sphere is moving all the time, and that's make it difficult. Your second question is as difficult as the first, which is the right to oblivion. It's Google, for example, is basically granting the right to oblivion to about 50% of the requests. Now, I know that lots of the requests are actually by politicians because they want to erase misdeeds, misbehaviors that they have done. But there are also things like there's a famous case of a pianist who gave a bad concert in Washington, and there were critics of that concert, and then he wanted those critics to be erased. And as you said, there's a question about what kind of information can you keep, and what should be erased. And for kids, that sounds kind of obvious, both because they don't have all the information about the consequences of their acts, they may be more impulsive, and they have a life ahead of them, so having a second chance is kind of crucial. But then if you think about atrocities, or forget even about atrocities, just think about corruption. Okay, so it all depends on basically several things. The first is I guess one of the main ones is sensitivity of what's going to be done with that information. So, you know, maybe a politician was being corrupt and has paid for it. Maybe for his private life, he might actually get a second chance, but he may not get a second chance to run for election, for example, because there's a real issue of doing the same thing again. So in the end, that depends on basically what application is made of this information. Is that to develop a private relationship, a social relationship, or is that to run for election again, for example? It depends also on how whether your type is likely to change, whether you're likely to have made a mistake, or is that something that you did very deliberately, right? And all those things. So there are lots of parameters, and you know the research I'm doing with Renato Gomez, for example, is still ongoing. You know, we are still thinking about all those issues, and at this stage, it's very hard. But you know, again, it's not a new issue. It's getting very prominent because of platforms and internet, that information is going to stay there for a very long time, and that's why we have to reconsider all our regulations concerning that. But it's a very difficult question.
Muito obrigado, Professor Tirole.
Thank you, Professor Tirole. Before I turn the floor to Professor Nakano, I would like to return the floor to Professor Carlos Ivan, and then we go to Professor Nakano. Professor Carlos Ivan, you have the floor.
It seems to me that what we are actually discussing is a definition of individualism. There are several experiments going on around the world regarding the control of privacy. One is the Chinese experiment that is evolving right now. Another one is the American. And the third one is the European. And it seems to me that in all these three big experiments, the definition, the hidden assumptions about individualism are working very heavily. I have an intuition that Brazil precipitated itself when it copied the European law. We should have waited a little bit more. There are questions of efficiency in terms of cost. There are questions of efficacy in terms of structure that have not been answered, and we plunged just because European law looks nice, we decided to copy it. It is not 100%, it doesn't fit 100% with our culture, and it's quite obviously is going to create a lot of problems here regarding the economics of the country. So anytime that we try to regulate something like this, why do we forget that price, that cost, may be one of the best tools to regulate things? Why don't we use cost? Why don't we try to minimize the problems instead of trying to solve them completely? That is my question. Thank you.
Obrigado, Professor Carlos Ivan. Professor Tirole.
Thank you, Professor Ivan. Professor Tirole, you have the floor.
I'm really sorry. I didn't get the translation of Professor Carlos Evans. So there was a moment in which I tried to signal that I didn't get the translation. So maybe if you could summarize the question. I'm really sorry about that, but I just didn't get it.
Professor Carlos Ivan, o senhor está com o microfone desligado.
Professor Ivan, is your microphone on? My question is the following. There are today in the world at least 3 major experiments concerning data regulation and privacy. The most famous one is the European experiment due to the new law on data protection in Europe. Brazil has copied that law. The second experiment, which is usually called an enhancement on dictatorship on a police state, is the Chinese experiment. And the third experiment is the non-experiment, or rather total freedom of the United States. So it's 3 different viewpoints. It seems to me that people who discuss this matter forget something. Namely, that these experiments are there to deal with individualism. And each one of these regions of the world have different definitions underlying the issue of individualism. In Europe, you have individualism coming from Illuminism. You have a Judeo-Christian conception, and the individualism of Voltaire, Rousseau, Kant. In the United States, you have individualism inherited from the British and perfected by the Americans. And in China, you have Lao Tse, that has nothing to do with Judeo-Christian religions. So, you want to discuss the whole thing as if it were one single thing, but it isn't. We in Brazil copied the European law, even though we are very similar to Europe, we are not exactly the same as Europe. So I think we sort of rushed through it. It was precipitated. It will bring in a very high economic cost. It is inefficient from an economic point of view, and its efficacy is going to be denied. It's going to be difficult to have it to work. So the whole problem lies in knowing the following. Given the sophistication of the problem, I wonder sometimes if it wasn't perhaps simpler to go back to the idea that instead of rationing, you should allow prices to go up. Which one is the most adequate solution? If you live in the socialist world, you want to be more egalitarian, maybe rationing is better. But if you live in a world of competition, maybe the price solution, the cost solution is better. This is very clear. There is no discussion on data protection between Europe and the United States. In Brazil, we have to make our own choice, and we precipitated a decision adopting the general data protection law in Brazil based on the European law without being able to go back. this is a problem because this affects economic efficiency, the efficacy of institutions, and we are not certain whether we are truly defending the aspiration for individualism that our society wants. Not to mention that with the progress of technology and artificial intelligence, the penetration of data everywhere, everything that is done now on data regulation will be knocked down in 5 to 10 years. The price solution would perhaps be better. You want to spread something, you want to publicize something, you have to pay. I think we have to adopt solutions. From my point of view, the solutions that we are beginning to use now, they are not working. Thank you. Thank you, Professor. Professor Tirole, you have the floor.
Well, thank you for another very difficult question, of course, but I agree with you that, of course, we have different backgrounds, different countries have different backgrounds and different views about privacy, what privacy means. And that raises the issue of whether one size fits all, and that's really very much your concern. At the same time, it's going to be very difficult to have a world in which regulations are very different across countries. It's a standard thing that it's very hard for a global firm to operate in countries with different antitrust regulation and different requirements for privacy and different this and different that, because it's very costly to do them, to adjust to that in terms of the cost of doing business. So, my own view is, I'm critical of GDPR as you are, but at the same time, I think we need a regulation. Of course, having the state have access to the data and use that for repression purposes we don't want, but I think the US on that front has been too passive. And by the way, that's a general remark about the US, which is the US, in the US, the internet has developed in a relatively unregulated manner, with very little accountability for our editorial rules, very little antitrust, very little this and very little that, which may have been good for a while, but now you see there is a terrible backlash or techlash against those companies because the regulation is not in place. And actually the companies may end up with regulations which are worse than what they would have been if they had contributed to designing smart regulation. Now, what is smart regulation is another issue. And you mentioned the price mechanism, which is a very good mechanism in general, but the issue is how to apply it in the realm of privacy, because for a market to work well, and I'm not going to tell you that, of course you know it, for a market to work well, you need to have absence of externalities, you need to have symmetric information and the like, and what I argue at the start is the market for privacy is not working well at this stage, for various reasons, there are data externalities. We don't know what contract we are entering in as a consumer. I certainly don't know what's going to happen with my data and what the consequences for me will be in 10 years, and so on and so forth. So just like as usual, what regulation is about is not to prevent market from functioning, actually to help them function better, to make it easier for them. And, to make sure that when I go on the internet, I feel pretty safe. And then I can use the internet, quite a lot because I feel safe about what's going to happen with my data. And that's the environment I would like to create. No, I don't have, a solution, a clear solution to offer. You know, insights here and there, but not a comprehensive solution to that. And you know, I think it's as I mentioned earlier, it's our job actually to think about those smart regulation. I think the firms should, instead of opposing regulation, you know, my general view is that the firms actually should participate in the regulatory process and try to find bright ways of protecting consumers without killing innovation. And that's part of the thing. And we're not there yet in the case of privacy, that's for sure.
Muito obrigado, professor Tirole.
Thank you very much, Professor Tirole. I would like to invite Professor Yoshiaki Takano, the director of the School of Economics of FGV in São Paulo. Professor Nakano, you're most welcome. Thank you very much for the honorable invitation to participate in this discussion. Indeed, Professor Tirole has fully met our expectations. We knew some of his books and articles, but really he made a brilliant explanation that raised a whole series of questions. I will focus on two aspects. First of all, concerning the transfer. I believe that a great benefit brought in by the new technology, the information technology, is the dissemination of information, the huge availability of data. And I also agree when he shows the incentives brought in by transparency, and also about the improvement in the allocation of resources, the efficiency in this allocation of resources. Also avoiding matches, wrong matches. But my question would be the following. Is this abundance of information, besides incentives and improvement in resource allocation, don't you think it also brings in something else, which is the revival of traditional microeconomic theory, not as an explanation of reality, but as a standard to be used? Because my theory is that this availability of information, this access to information, allows you to create auctions that are similar to what you find in the literature. It allows for increasing accountability of people providing information. So I imagine that for a country like Brazil, regulation should perhaps rather be focused on this type of information to use the great availability of data to encourage competition, and this would lead to better well-being in society. My question is, don't we have the opportunity now to create auctions and create an institutional environment simulating a competitive model, the same model as you find in literature about economic theory? Another issue I would like to raise is the following. In a country such as Brazil, we live in a country of rights, and we totally forget duties for citizens. Our educational system is terrible, and it does not create responsibilities, which is the opposite of a country such as Japan, where there is more accountability than rights. And everything, the whole school system emphasizes duties more than rights. So, in a divided society such as ours, what prevails is the interest of certain small, well-organized groups. The regulation we ought to have, shouldn't it be more flexible? Professor Tirole mentioned the adaptability of regulations. Well, maybe it's more adequate because it involves time. And he also said it was a precipitation to copy the European law. My opinion is that we should hold a much wider discussion to get citizens to be more accountable for the information that they provide and that they show on the internet. Thank you. Thank you, Professor Nakano. Professor Tirole, you have the floor.
Well, thank you, Professor Nakano. Thank you for your kind words. And part of your question is about data sharing, the diffusion of data, which is, of course, very important in order to develop brand new services. I'm thinking about artificial intelligence and machine learning. You need a lot of data, and you have to pull different data sets so as to together in order to achieve those services. So there is a kind of public good aspect to data, which of course enters into conflict at this stage with privacy, because if you let data to be shared among many participants, then you infringe on privacy if things are not done well. Interestingly, by the way, in Europe, GDPR was not done in collaboration with DG Comp, which is a competition authority. And that had actually some implication, because GDPR actually makes it a bit harder to resell the data. And Google, which are the two firms which have a lot of data, they didn't mind so much GDPR, because what matters for competition is not the absolute advantage, but the relative advantage compared to the competitors. And if you have many more data than the others, then basically making it difficult to resell data is not that bad for you. Now, there is a question I don't master at all, which is a question about whether you can trade data while keeping privacy. And actually, it's a computer science question. Computer scientists have been working on that for a while. I mean, you can anonymize the data as much as you can, but of course, you know, lots of computer scientists play the game of de-anonymizing data. So you have data which are anonymized, but you know, with a couple of things, you know, then you can basically pin down who it is exactly. So you don't have the name, you don't have the address, you don't have any of that, but you can still figure out who it is, because you have so much data that you can basically recoup the person. So and that's very important, because that solution, I mean, people talk about, for example, adding noise in order to make it more difficult to de-anonymize. It's very important, but it's going to condition very much on whether we'll have data resale. So in principle, we would like to promote data resale, because data is just like a public good, and you want all the firms to be able to use the data in order to build new services. But at the same time, you have to preserve privacy, and that will depend on how much you'll be able to anonymize the data. So that's actually very important. Create auctions for data, yes, maybe, except that, as I mentioned, data in principle is a public good. And in principle, you like mini agents to be able to profit from that. And you are worried about basically the big firms like Facebook and Google selling the data only to friendly companies who are not competing with them. That's a possibility. But selling data, we know, is not easy, because you have to know exactly. You have an asymmetric information issue again. Are the data well organized? Are they easy to exploit? Are they reliable? Because that's also very important. The data may be collected in a reliable or unreliable way. So all those things are important. Auctions work well when you have a well-defined good for auction. But if you don't know what you are buying, because you don't know whether the firm has exerted care in collecting the data, what kind of people it has data on, and so on, it's kind of difficult to do. On the issue of Brazil being a country of right as opposed to duties, of course, I'm not a good judge of that. I cannot tell. It's clear that we all have more duties. We have to work on what's called norm-based interventions. In sociology, people work on norm-based interventions of trying to change a social norm in order for people to behave better. And sometimes it works, and sometimes it doesn't. I mean, an example where it doesn't is climate change. It has been 29 years since the Rio summit on climate change. And to be honest, we have done very little to fight climate change. We talk a lot about it. There's a lot of posturing about climate change. But in terms of actions by governments and private companies and by citizens, there is not that much which is being done. And that has been 30 years, almost 30 years since the Rio summit. And so we need a combination of sociological intervention and try to emphasize the duties of people and not only their rights. And I agree with you on that. But at the same time, at some point, and you're an economist, obviously we need incentives, because as long as we don't have a sizable carbon price, not much is going to happen, or the wrong kind of actions are not going to be chosen.
Muito obrigado, professor Nakano, professor Tirole. Professor Tirole.
Thank you, Professor Tirole Nakano. Professor Tirole, we are going to send you our thanks, and I would like to return to you the opportunity of your last considerations. Anything you would like to say?
I just want to thank you again for the opportunity and for the great questions. Of course, there are hard questions to answer, so it didn't make my life easy, but thanks so much for inviting me, and good luck to FGV, and I hope to visit in the near future once this all COVID stuff will be over. Thank you.
Muito obrigado, professor Tirole.
Thank you, Professor Tirole. And this was the beginning of my presentation. It was fantastic to be able to have you here with us virtually. And we hope that by the end of the pandemics, we can meet face to face. It will be an honor to all of us. So I thank you, Professor Tirole. I thank for the Foundation Getulio Vargas, and on behalf of his president, Carlos Ivan, to Mr. Justice Luiz Fux for his presence, Dr. Sidney, and the board of FGV represented by Professor Guerra. I also thank the debaters, Professor Goretti, Professor Oscar Vilhena, Professor Nakano. Thank you very much for your questions.
Agradeço a parceria dos meus queridos colegas, professor Armando Castelar.
I thank you, Professor Armando Castelar, Professor Patricia, that coordinated this project together with me, and their participation. and that in somehow will materialize part of our dream that was to bring Professor Tirole here for a presentation to us. I thank all the technical team that help us in organizing this event, and last but not least, all those who also join, even if virtually, including here my students. So have a nice day, good afternoon, and until next week.